Hi there. Welcome to another edition of Winning Wednesday, brought to you by Adair Thurston. I'm Gabriela Vega, an immigration attorney at Adair Thurston. And today joining me is my friend and colleague, family law attorney, Autumn Fox. Autumn, welcome.
Thank you.
Share a little bit about your practice area and what made you become a family law attorney with our friends to start off with, if you don't mind.
So I have been a family law lawyer for almost 20 years. I graduated from University of Kansas School of Law in 1997, and then I clerked for a judge at the Kansas Court of Appeals, and then went to a large law firm in Kansas City, not doing family law. But children are my passion and have always been my passion, and so I turned to family law largely to address the needs of children.
Wonderful. And I think that that's really important, right? Because the reality is that you have to be child-centered in family law. Wouldn't you agree?
I absolutely agree that you have to be child-centered in family law. It's not always true that people are child-centered, but lawyers, courts, judges should all be child-centered in family law.
Absolutely, absolutely. Well, so I'm really excited to have you here. As you know, Winning Wednesday is done every week, and every week we bring up different topics of different areas of law, where our goal is to help our friends and family and clients out there become better informed consumers of legal services,
yes.
Right? And so I know that next week we are very excited about our topic discussion, child support
and the
issues
that were made in 2020.
Yes, that's exactly right. And it dawned on us that just talking about child support is kind of a complex issue in itself. And maybe what we needed to do was start talking about today, giving a primer about custody basics that will then help inform our conversation next week about child support and how it's calculated.
I think that knowing the basics of child custody informs clients and is necessary to inform clients about child support.
Absolutely.
They seem like two separate things, but they are intertwined.
I agree. So with that being said, you guys, I'm so excited. I'm going to be asking Autumn, our friend Autumn, some questions about child support basics. And I think that, Autumn, the best place that we can start is by giving ourselves a good basic understanding of definitions in child custody cases. Okay?
Okay.
So I'm going to start off by asking you a couple of questions, and if you could give us a working definition.
Sure.
That obviously I know I don't expect the statutory definition, but something that the regular human non-lawyer person can understand. Non-lawyer speak. That's exactly right. Okay, so definitions. What is custody?
So most people are confused about what custody is because there are two types of custody.
Absolutely.
There is legal custody of a child, and then there is residential custody of a child. So legal custody is defined as basically who gets to make the day-to-day decisions regarding the child's life. And that is generally sole legal custody or joint legal custody. So generally speaking, it's joint legal custody, meaning both parents have a right to make day-to-day decisions regarding their child. Sole legal custody is granted only on a specific finding by the court. And then residential custody, which is really what most people are speaking about, is where is the child going to live? Mm-hmm. With which parent is the child going to live? Or children.
Absolutely. So residential custody is, and another good way of saying that is residential placement. Where is the child placed on a more permanent basis, do you think? Is that appropriate? Or how does residential placement differ?
I think residential placement is probably it's a more child-friendly term. Mm-hmm. Residential custody, you almost think of custody of an object rather than a child living somewhere. Absolutely. So I would actually like it to say residential living placement. Where is the child going to live? With whom is the child going to live?
Right. And so when people talk about custody, of course, their big issue is, I want custody. And what they're referring to is where the child sleeps on a day-to-day basis.
Right. They think, so there's confusion frequently. People think that joint custody means where the child lives. What they're really speaking of is shared residential custody. So here are the types of custody, and a little bit of everything in between, but generally
Lots of
speaking,
definitions
there are. So primary residential custody means that the child or children lives primarily with one parent and has parenting time with the other. That is a statutory definition. Divided custody, also a statutory definition, means that if there is more than one child in the family, one child might live with one parent and the other with another. That is a rare order for a court to issue, but that is the second statutory definition. Shared residential custody actually is not found in the Kansas statutes. It's found in the Kansas Child Support Guidelines. And until 2020, it was defined as a sharing or nearly equal sharing of time and expenses. So that means that the child would spend nearly equal time, as close to 50% as you could get, with each parent, and each parent has to also share in the expenses. In 2020, with the changes to the Child Support Guidelines, which we'll speak more about next Wednesday, it is now defined as an equal sharing of time and expense. That means basically to the minute. And so we'll see what that change does in terms of those seeking shared residential custody.
Absolutely. And so that leads to an important thing. When you're talking custody, residential shared custody, these types of things, all of this information is usually contained in some sort of document, right?
Right.
What is that document called? And can you explain a little bit about what goes into that type of document?
So there are a couple of documents, but I think the one that's the most important for people to know about is that there would be a parenting plan. Mm-hmm. There's going to be an order where the judge orders who has what type of custody, but the parenting plan is the document that's the most important. That sets forth who has custody, and then it sets forth which, if it's, say we have primary residential custody, the child lives primarily with one parent, then there's a parenting plan that says what parenting time the other parent has. And hopefully that's not an exclusive list, but one that has been set forth either by the court or agreement of the parties, and hopefully then the parties can get along well enough on behalf of the child to make that their outline, but not the only time that they have parenting time.
Right. Perfect. So the parenting plan then becomes basically their outline for how they share the time of the child that they share.
Right.
Okay. Now, when we refer to, and I think you said it a while ago, did you refer to something, parenting time?
I did.
Okay, so can you explain a little bit, what is parenting time and what does that mean for the two parties involved in a custody case?
So if one parent is granted primary residential custody, then the other parent has parenting time. I think what most parenting time is the time that the non-residential parent, the one the child does not live with the most of the time, is the time that they are guaranteed by order of the court to have with the child.
So when we were growing up, people used to call that visitation, right?
They used to call it visitation.
With their kids. I'm getting a visit with my kids.
Right. They used to call it visitation. Kansas changed to parenting time a number of years ago. Some states call it something even stranger. The state of Texas calls it periods of possession. And so Kansas changed it from visitation to parenting time to emphasize that both parents are parenting.
Very cool. Now, we've got a working definition of some of these topics, of these terms. Let's try to put it all together. Okay? All of these issues that have to do with custody, with parenting time, what are the types of cases that you could help a client in a case where there's custody issues involved? And obviously people know divorce, right? But the divorce isn't the only place where custody is an issue. So what are some of the areas that you could share with people that are issues in custody?
Right. So divorce is not the only place. Obviously we can help with the issue of custody in a divorce case. Sometimes the parties have never been married, so that would be called a paternity action. So that is establishing who the father of the child might be, and then again, who has custody, who has legal custody, and what parenting time there will be. So paternity action is another one.
And as part of the paternity action, that's also a place where they can do child support issues.
Child support issues as well, right. And actually there are some other places that people might not think about. So there's something called a child need of care case, and that's when there's some problems in the home, and the state steps in, and the child might be placed in the custody of the state of Kansas, but the whole goal is to reintegrate the children or child with their parents. And so parenting time becomes an issue then too. How much time does the parent have in seeking to reintegrate them with their family?
Okay. And those are all the types of cases that you would help a client with?
No, also there are post-divorce motions. So let's say that one parent, in this instance, let's say that the mother had custody after the divorce, whether that was a court order or by agreement of the parties. And as a post-divorce motion, sometime later, decides that that situation is not working well for the child and they want to change custody. Those are, without question, motions that I can help with, and they're very common motions. Sometimes the initial decision, whether it's by the parties or by a judge, just doesn't work out for the child, and so
life changes.
Right, life changes. The child changes, and so then a post-divorce motion is filed, and that same thing can happen in a paternity case. So in a paternity case, if someone is granted custody, let's say it's the mother, then there's a post-divorce motion where it's the father who's seeking custody, and those are very common.
Absolutely.
Post-divorce motions.
Oh, absolutely. I think you get, especially in a community like Manhattan, Kansas, like Riley County, you get involved and you get divorced. You set out a plan that you think works for you, but years later you could have a situation where a new job opportunity in Kansas City presents itself.
Right.
That is a post-divorce motion, you're referring to.
That's a post-divorce motion, which is called a move-away case. So, and there's case law on move-away cases, and most judges in the state of Kansas don't like children to have to move away from where they've been living and been raised, and so there are certain things then that the parents seeking to move would have to prove to a court before they could take the child with them.
Right. And so and any time that a parent is sharing a child with someone with whom they don't live, they can come talk to you and see if there's something that needs to be addressed.
They can. I think that many parents aren't aware of what type of motions can be filed, that it's not as, I think they think it's more limited than it is.
Absolutely.
Right.
Absolutely.
And sometimes children don't get to choose where they want to live in the state of Kansas.
No. Don't jump into that yet.
Okay.
I've got
a later portion. I'm ahead of myself. Never mind.
I've got a later portion where we're going to be discussing some myths and misconceptions about family law, and that you'll answer
and
for
there are
us.
many.
There are. But so now we've got all these types of cases in which you could become involved, in which child custody becomes an issue. I think the most important thing, and I think that people that are parents, the most important question that they would have is, what are the goals of a court in a child custody case? Because obviously everybody has their own goals, their own agenda.
Right.
But what is it that they have to what is the court's goals? That's a simple question.
The standard by which the court determines child custody, whether it's legal custody or particularly residential custody, is what is in the best interest of the child. And so in determining what is in the best interest of the child, there are a number of statutory factors that the court looks at. They are not limited to those statutory factors. Other factors can be looked at as well. But there is a specific statute that the court looks at. But we don't need to know what each of those factors are. What we need to know is that a court is required as a matter of law to look out for the best interest of the child. And that's the standard they're using when they make a decision regarding custody.
So anything that a parent might want to do, they should be contemplating to themselves. Is the court going to see what I want as a best interest for my child?
They should think about that. And by the way, before doing anything with custody, one thing that we offer as well is to come in for a consultation to determine, and we can look at the statute, look at all the factors that a court's going to look at additional factors that the parent may have, and whether that motion will be successful or may not be successful.
So you'll even talk through with people about that type of thing.
Right, because most parents don't know the factors that a court looks at in determining the best interest of a child.
Absolutely. Well, to that end, let me ask you a question. What are some of the factors that the court, if you can recall?
I actually can. So the age of the children, the age of the children, the parents' desires as to custody, then there are a few more. The children's community and how attached they are to that community. The most important one to me, and the most important one to many judges, is the ability of one parent to sustain a relationship with the other parent. So put differently, can you parent together without having an adverse impact on your child? There's some factors like, has one of the parents had a criminal record? Is one of the parents a sexual offender, or do they have a sexual offender living in their home? So there are a number of factors outside of that, but those are the ones that come to mind immediately. Absolutely. Especially the one about whether, and by the way, the party's ability to communicate. Often in the midst of a divorce, parties really do not communicate well. Right. And so they need to demonstrate to a court that they can communicate well on behalf of their children.
Absolutely. Now, I think you already answered this question, but let's delve into it a little bit more deeply. Is it possible to modify old parenting plans? I mean, that's what you were discussing with post-divorce motions, right?
Yes, you can modify parenting plans as well. It's not limited to modifying custody. So if the parents can't agree on modifying the parenting time, then you can seek to file a motion to modify the parenting time itself. Yes, okay. Absolutely.
Perfect. What are some of the steps that would go into modifying an old parenting plan or a parenting time? What are some of the things that you are going to ask of a client to provide you when they're contemplating to hire you?
So first of all, I would need access to or a copy of all of the documents for the current parenting plan and the divorce or the paternity action, whatever that might be. Right. I would need to know the history of what's happened from the time of that order being entered to their wanting to seek change in that parenting time, including information about their children. And then from there, we would file a motion to change the parenting time. And I would really want a history. I think that custody lawyers in particular, we need to know the story. That is, what's going on within the family, what's going on with the child. So why are you here to seek to get that parenting time changed? I think that's really critical.
Absolutely. Now, let's talk a little bit about some frequently asked questions, because I think that although we've, again, touched upon some basics, I think that it's important to delve into some of the questions that people do have themselves. What do courts need in order to get involved in, or why do courts need to get involved in cases? I mean, let's say that and obviously divorce has a different connotation. There's a lot of times financial property involved. Right. But like a paternity case, right? I just had a baby with someone. Why do I need to get a court involved? Why can't I just say, you know what, you can come pick him up on Fridays and bring them back on Saturdays, and that's going to be good enough?
The reason in that situation why a court needs to get involved and issue orders is because basically that parent, and not in every situation, but in most situations, the parent has no legal rights to the child, and there is no legal agreement that would enforce their parenting time. And so it's very frequent that as time goes by, the one parent might get involved in a new relationship, something else might change, like that move that we talked about, they might want to move. And if you don't have orders from the court regarding the paternity and the parenting time, they can move and and the parent without any legal rights can do nothing about it. So right. It's to establish your legal rights. It's to sometimes change the last name of the child to match that of the father if a father's filing. And it is to have an order, an agreed or ordered parenting plan that someone can say, okay, this is my parenting time, and I'd like that parenting time now, please.
Absolutely. So the only way that you can really enforce your rights is by having a court outline what they are.
Right. And
Involving family law.
right. And a lot of documents that parties can file in a divorce are now available on the Kansas Supreme Court website, which is www.kscourts.org. And when people try to get divorced themselves, they're called pro se litigants. In other words, they're representing themselves. Where children aren't involved and no property is involved, those cases are pretty easy, perhaps, for a court and for the parties. But when custody is involved, it's very, very difficult for people to know on their own the steps that have to be taken to gain custody or change custody or gain parenting time or change parenting time.
Absolutely. Well, and I found, because as you know, Autumn, I have also done a little bit of family law in my time. I have found that a lot of times when people try to do the work on their own, and this is not to disparage people who try to represent themselves, one of the things that may happen is that something falls through the cracks, and then later on they're stuck having to deal with this situation. An example in town, I'm sure you've heard this, right? Like, we agreed on child support, but I'm getting all these medical expenses for our kid, and the other parent doesn't want to reimburse them.
Right. Things fall through the crack in that way, also because the judge, whoever's hearing the case, is not allowed to advise the parties if they're representing themselves, because they are not the advocate. They are the finder of fact, in other words, the judge.
The decision maker.
Right, the decision maker. Right.
Absolutely. So having a little bit of legal help can save you time and money in the future, because I imagine you don't let those little things fall through the crack.
Right, little things fall through the crack. But the other thing that I think it's important for those who are trying to represent themselves to know is, if you have a hearing, if you have a trial in front of a judge, you are, as a matter of law, expected to know what a lawyer knows. So some judges give you a little leeway, but you are expected to know the rules of evidence. You're expected to know the law. You're expected to know everything that a lawyer knows, even though you're not a lawyer. And so sometimes you may have a situation where one party has a lawyer, the other is representing themselves, but both of them are expected to act like a lawyer, know the rules of how they're to present themselves in court, the rules of evidence, and the laws of the state of Kansas. And people who are representing themselves really don't know those things, not out of ignorance, simply because they haven't studied it.
They haven't taken the time to study it, or haven't had the chance to study it like we have, for sure. Now, I wanted to ask you, if a person can, ask, what are some of the other things that a lawyer can offer in a family law case?
Family law meaning custody, family law meaning
what are the yes, okay, you know the law. What are the other advantages to it?
We offer adoption, and that adoption can be a voluntary adoption, one that's not voluntary, a step parent. We offer step parent adoptions.
Absolutely.
And then I spoke earlier about a child in need of care case, and when a child is in need, the state steps in, and sometimes, in spite of the state's best efforts, the parents are never reintegrated with their children. And so then someone else adopts them. So, for example, it may be grandparents that adopt them. So at the end of a child in need of care case, we offer the ability for them to adopt their grandchildren out of that child in need of care case, because the parents' rights have been terminated. So we also offer, though, to represent the parents whose the state is seeking to terminate their rights. So we represent parents as well. Guardianships, we offer guardianships as well.
And then, as people that are contemplating marriage, prenuptial agreements, is that something that you like to do, or that you ever do?
Prenuptial agreements, yes. The one piece of advice I give people about prenuptial agreements is they can be extraordinarily well written and detailed, which is what they should be, but the other party can still always litigate that matter.
Absolutely.
Right.
Well, you can always
you can try to litigate anything. It doesn't mean you'll prevail.
Oh, so this is a good question somebody asked. If I were a man and got a divorce from my wife, is she more likely to get custody of children simply because she is the mother?
It's a really great question, and it's a myth and misconception, although there's some history to it.
That's on my
So the
list.
answer to that question, first of all, is no. The mother is not more likely to get custody simply because she's a woman and she's the mother. So Kansas had for many years what's called the tender years doctrine, and that meant that children should spend their tender years with their mother. And during that time frame, mothers largely were granted primary residential custody of their children. For many years now, that has not been true. It's the best interest of the child. And in my practice over 20 years, I have represented as many fathers as I have mothers. And it is who is the best parent, who's going to best parent, who's going to look out for the best interest of the children. And I have just as many fathers who have primary residential custody as mothers. So just because you're the father does not mean you're not going to get custody.
Yeah, and in fact, for those who think that mother automatically gets preferential treatment, that's actually against the law.
That's contrary to Kansas law, right? Because the tender years doctrine is not part of Kansas law anymore and has not been for a long time.
So now let's talk about myths and misconceptions. We have a few minutes left, and I that was a great question to get us into the myths and misconceptions, because one of my first myth. And so myth and misconception say true, or I'm going to tell you if they're true or false, right?
Okay.
Was dads never get custody, or another way people say it, moms always get custody, or Kansas is a mom state?
Absolutely false. And I find Kansas to be less of a mom state even than others in terms of the courts complying with the law.
Absolutely. Myth number 2, when my kid gets old enough, they can decide what parent they want to live with.
False. There is no age at which a child gets to decide where they want to live. There is an age at which a court may appoint a lawyer to represent the children to ask them what their desires are, and the court can consider that, but there is no age at which a child gets to decide where they want to live, not even 17. There's case law on that. There is no age at which they get to decide.
So in that type of case, how do you try to nurture the parent or the desires of or the needs of the child? Is it more about counseling and trying to find a time frame that works for the child?
So there are a number of ways that a child's wishes can be made known to the court. The guardian ad litem, which is what I just spoke about, can be appointed. That's a lawyer for the child. Guardian ad litem in Latin literally means next friend. So the guardian ad litem would do an investigation, which includes speaking to the child, and then they file a report with the court, and they also actually take part in the trial. So a guardian ad litem. You can have a child custody evaluator, and that's someone who evaluates both parents, the children, anyone else that they think is pertinent to speak with, and issues a report and also testifies. And you can have, let's see, we talked about guardian ad litem, child custody evaluator. There was one other in my head, but it's escaped me for the moment.
Oh, that's okay.
Just saying, it's escaped me for the moment. It will
come back, and you'll remind people next Wednesday.
Wait a minute, now I remember. It's a counselor. So let's say that a child has been seeing a counselor for an extended period of time. Not counseling only for the purpose of determining custody, but has been seeing the counselor for an extended period of time. Many counselors, depending on the issue, have been determined to be experts in Kansas courts, and that counselor can testify as to the child and the child's desires.
Oh, okay. Very cool. So now another side of my kid gets to decide. I think this is another similar myth to that.
Wait, one more.
Or
case managers.
Potential myth.
Case managers, that's when your case has gotten to be so bad that you basically can't speak to each other anymore, and you want to pay for 2 lawyers. And a case manager is appointed under some very specific statutory guidelines, and a case manager can also make a report to the court as to the child's desires. Okay, that's it. That's the list.
That's the list. Okay, so myth number 3. My kid can choose whether or not she or he wants to have parenting time with a non-custodial parent.
The child can't choose that either. But here's a reality. When a child gets old enough and the child does not want to be with one parent, it's very difficult. What are you going to do? Are you going to put them in a car and force them to go? But the answer as a matter of law is a child may not decide if they want parenting time or not, nor should any parent encourage them to make that decision.
Absolutely. Myth number 4. I don't need to pay child support if I don't get parenting time with my kid.
Absolutely false. Child support by statute is the right of the child, and If you're not getting your parenting time, that's the time to come file a motion to enforce your parenting time, a motion for a change of custody, whatever needs to be filed so that the court knows that you're not getting your parenting time. But it does not affect at all that your obligation to pay your child support on a monthly basis.
And then myth number 5, I can move to a different state with my child without giving notice to the other parent, since she or he never sees the child anyway.
That is not true either. As a matter of statutory law, you have to give 30 days written notice prior to moving, and that gives the other parent the opportunity to file an action that would cause you not to be able to move away from the state of Kansas. That's that move away case that I was talking about. So just because you want to move does not mean that the child gets to move with you. But the bottom line is you have to give notice, even if the other parent isn't seeing the child, so that you've complied with the laws of the state of Kansas, and then may be able to get to move.
Okay. I am so glad that we were able to give people a primer. I think that this primer will be very beneficial for next Wednesday's presentation on child support. Then we will be talking about child support, how it's calculated in the state of Kansas. Our wonderful wealth of knowledge, Miss Autumn Fox, will be with us yet again to talk child support. Any closing thoughts for our friends?
My closing thoughts regarding custody is it really should be child-centered. And so the people who can make the best decisions regarding their children are their parents. But if you can't make the decisions together, then come to a lawyer who has experience, who knows about child custody, but more than that, who cares about the children. I don't ever meet the children. I shouldn't meet the children. I'm a lawyer. They shouldn't see or know me. But my passion is for the children, and that's the lawyer that you want, is someone, not just me, but a lawyer who cares about your child and children.
Absolutely. Thank you
Okay.
so much for
You're
joining
welcome.
me. Thank you all. We'll see you next Wednesday.
See you next Wednesday. Child support 2020 updates.
You did really good.
I did.
Yes, absolutely.